Thank you to everybody for showing up, and particular thank you to Professor Blackman for coming today.
Not coming. I walk into my office. I haven't gone very far.
That's okay. You put on a coat and tie, so you're far ahead of many of us these days. And I'd like to also just thank some of our guests for coming today. I see Justice Womack is on the phone from the Arkansas Supreme Court. I see Judge Radofsky is on.
Welcome.
And Lieutenant Governor Griffin.
Welcome.
Thank you all. Thank you all for joining. I'd like to just briefly introduce our speaker, and my notes are over here, so I'm looking off to the side, a Zoom feature. Professor Blackman, thank you very much for joining us today. For those of you who aren't familiar with him, he's probably one of, if not the most prolific Federalist Society speaker around the country. He always seems to be speaking somewhere, and so we're very glad that he took time to speak to us today. Professor Blackman is an assistant professor at the South Texas College of Law in Houston. His specialties are in the area of constitutional law, the United States Supreme Court, and the intersection of law and technology. Professor Blackman's written several books, including Unprecedented, the Constitutional Challenge to Obamacare, and Unravel, Obamacare, Religious Liberty, and Executive Power. And his newest book.
Whoa, look at this. He's got it. And you have the new one. See that little red triangle in the corner? That's actually the new and improved version. So I am impressed.
It is the 100 Supreme Court cases that everyone should know. This is an excellent book for those of you who didn't get maybe the right teachings of constitutional law in law school. It's an outstanding book, and I highly recommend it to all of you. And Professor Blackman is, like I mentioned, very prolific. He writes constantly. He writes for Cato Institute, and he blogs, and he's a member of the Ballot Conspiracy, where every day we find out the Supreme Court history, historical dates from Professor Blackman. He always lets you know what happened on that day in Supreme Court history.
Glad someone likes that feature.
He's written dozens of law review articles, and his commentaries appeared in places such as the New York Times, Wall Street Journal, Washington Post, USA Today, and many other places. I'm very happy that he took the time to join us today. And with that, I'll turn it over to Professor Blackman.
Thank you so much. It's a pleasure to be here. I was only in Little Rock once when I moved from Louisville to Houston. I drove all the way south through Little Rock, and I enjoyed the visit. But I hope to be back in Little Rock soon enough to visit some of my friends there. I saw Judge Radofsky at a conference recently before everything blew up, so it's good to be in good company. The topic Chad asked me to write about was Corona and the Constitution. And this is a topic that none of us ever thought much about, right? We learn about epidemics in school. We learn about, quarantine laws in the abstract, but we've never really had to deal with this in the modern era. I'd like to discuss Corona in 6 different contexts. First, the free exercise of religion. Second, the freedom of association and the freedom of speech. Third, the Second Amendment, the right to bear arms. Fourth, abortion, of course. Fifth, voting rights. And I got enough hands here, yeah. Sixth, federalism, the balance between the state and the federal government. Because this is Zoom, we'll do some Q&A at the end. You can use the little blue hand function if you want to raise your hand, or you can use the little Q&A button to send questions to me. I can actually call on you and let you speak, which I think is a very nice feature for us to use. Let's start with the free exercise of religion. And we have a brand new Supreme Court case decided not even 2 days ago. Under Supreme Court precedent, the government can burden religion so long as they do so neutrally. That is, if all religions are equally burdened, or if religion is not singled out for specific harms, then the free exercise clause has not been violated. But what if the government does target religion? They enact a law that treats some practices okay, and punishes other practices. So let's take the famous case, Church of the Lukumi. In that case, the city tried to ban animal sacrifice. That's a ritual practice by the Santeria. If you want to be a hunter, you are free to slaughter animals, but if you were a member of this religious group, you could not. The law was basically gerrymandered in such a way that it banned this sort of religious practice. That's a no-no. More recently, we have the Masterpiece Cake Shop case, where you had evidence that the government in Colorado was targeting this religious baker named Jack Phillips in ways they weren't targeting other bakers. And again, the court said there's a violation of the free exercise clause. Okay, so now we get to Corona. In the immediate aftermath of this epidemic, states began to issue what are called stay-at-home orders, which you know about all too well, which basically said everyone must stay at home. But they didn't mean everyone. Almost immediately after these orders were issued, the government said certain essential businesses and institutions could remain open. What was essential? In some cases, grocery stores, certain types of hardware stores, lawyers' offices were deemed essential, go figure. Of course, courts were deemed essential, and some other very important governmental officials, police, firefighters, et cetera, were deemed essential. So it wasn't the case that everyone was shut home. In some states, houses of worship were deemed essential. In other states, they were not. So as we moved from March to April, we began having the first conflict, which was Easter Sunday. And the issue was this: can the state prohibit people from having a drive-through service, which is exactly what it sounds like? You drive your car into a church parking lot, you roll down your windows a itty-bitty bit, like they'll drive in movie theaters, and you listen to prayer, you listen to sermon, you listen to whatever the group wants to convey. And some governments actually suggest that the drive-in services were not allowed. Now, you could drive into Chick-fil-A or McDonald's or Burger King, but you couldn't drive into a church. And there was some litigation about this, right? You know, why can you drive to a Chick-fil-A, but you can't drive to a church? Well, the government said people might get out of the cars and they may decide to go to the bathroom, and having drive-through services puts people together and more likely to misbehave. And I think that argument is premised on frankly, a lack of trust that people of faith would comply with these distancing guidelines. Okay, but that was the first round. I think for the most part, the drive-through services are not an issue anymore. The more pressing concern was actually in-person worship. In-person worship. You know, let's say you have a church that can seat 1,000 people. You have some really big churches. And what if they say we want to fit 200 people, right? Are we allowed to actually space people out in this house of worship? And on this question, the circuit split. There was actually a pretty deep split that formed within a span of 2 weeks. The Fifth Circuit here in Texas, actually I think it was a Mississippi case to be precise. And the Sixth Circuit had I think it was an Ohio or a Michigan case. I'm blanking which state it was from. But there was a Fifth Circuit case and a Sixth Circuit case. And those courts said that the state can't exclude houses of worship from being deemed essential. And the argument was based on how many exceptions were granted. There were so many exceptions to these rules that at a certain point it looked like you were actually disfavoring houses of worship, that you were treating them a little bit differently. But the split formed quickly. You also had other decisions from the from the Seventh Circuit involving the Elim Romanian Pentecostal Church, and the Ninth Circuit, which was the South Bay United Pentecostal Church. And they sought rulings to assemble in their states on Pentecost Sunday, which just passed a few days ago. And they argued that the ban on in-person worship was too onerous, even if they were to be socially distanced. Now, the circuit courts ruled in favor of the churches, but both California and Illinois did something very crafty. You know, the new strategy is to prevent the court from ruling against you, you moot the case. So on the eve of the Pentecost Sunday, both California and Illinois issued revised policies, which said that, well, the churches can meet, they just have to limit themselves to 25% of the occupancy limit. So the issue presented before the Supreme Court was not the same issue presented before the Circuit Courts of Appeals. They know what they're doing. They can drag things out until it gets to the court, and they change their policy very conveniently. It happened in both cases. So this case goes to the Supreme Court. You have a Pentecostal church in California and a Pentecostal church in Illinois who seek to attend worship services. The Supreme Court splits 5-4 on this question. Sharply divided 5-4 decision, which came out, I think, Saturday morning around 1 a.m. It was pretty, I'm always awake. I'm up late anyway. I saw it in real time. But it came out pretty late at night. And the court put out this ruling. And the court split 5-4. How did it split? I'll say something that should sound familiar. Chief Justice Roberts voted with the court's liberal members. Oh, there I said it. I say it more often, it gets a little more natural. The majority did not write an opinion. It was simply a one-sentence order saying that the request for a stay is denied. But Chief Justice Roberts wrote a concurring opinion, which he doesn't do very often, concurring with the decision to deny the injunction. It was about 2 pages long. Justice Cavanaugh wrote a dissent that he would have granted it. Kavanaugh's dissent was joined by Justices Thomas and Gorsuch. Now you may be counting, wait a minute, Josh, it's 8. Well, Justice Alito would have granted the stay, but Justice Alito did not join the Kavanaugh dissent. Why? Maybe I'll speculate on it later. I have some theories, but not certain. Roberts and Kavanaugh disagreed on a very basic points. What types of business are comparable to houses of worship, right? If you want to think of employment law, right, what is the relevant comparator, right? What are you comparing a house of worship to? Roberts said that houses of worship are comparable, if you will, to other secular gatherings, like theaters, that are subject to restrictive guidelines. So, for example, Roberts said that houses of worship are similar to lectures, concerts, movie showings, spectator sports, theatrical performances. These are places where large groups of people gather in close proximity for extended times. California argued that having so many people in church where they're singing and projecting fluids and spitting, I know it sounds gross, but when you speak, you're spitting in the air, is different. Roberts says that the order of the governor treats more leniently dissimilar activities, such as a grocery store, a bank, a laundromat. In these places, people don't congregate in large groups, and they don't remain in close proximity for extended periods of time. Okay, that was the majority. Well, that was at least Roberts, who I'm sure the other justices didn't really care what he wrote, but that was Roberts. Kavanaugh, our newest member of the court, reached the exact opposite conclusion. Indeed, Justice Kavanaugh quoted at some length from a Sixth Circuit opinion from Judge Sutton. Kavanaugh beat Sutton for the Supreme Court, so I guess this is like his way of bringing Judge Sutton to the Supreme Court. But anyway, Justice Kavanaugh, I think, agreed with Judge Sutton. Justice Kavanaugh wrote that the church has agreed to abide by the state's rules that apply to comparable secular businesses. In other words, they'll wear masks, they'll sanitize their hands, right? They'll do all the things that the state requires. And Kavanaugh quotes Sutton, who wrote, "Why can someone walk safely down a grocery store aisle, but not a pew?" That's a good question. Why can someone safely interact with a brave delivery woman, but not with a stoic minister? It's also a good question. You may have seen on YouTube this video from Italy, where a police officer walks into a Roman Catholic mass during the middle of the central part of the service when they're doing the communion. And the cop asks the priest to stop the service, to immediately disperse everyone. And the priest says that your parishioners can watch you on Zoom as you do the service. You know what the priest says? He says, I'll pay the fine, right? In other words, write me a ticket, I'll pay the fine, leave me alone. And the cop wouldn't leave. Eventually he left, but it made a huge stir. But we're allowed to interact with a lot of people face-to-face indoors. But the state says you can do it with a delivery woman, but you can't do it with a minister. Cavanaugh writes, the church and its congregants simply want to be treated equally to comparable secular businesses. California trusts its residents to adhere to social distancing guidelines, but the state cannot assume the worst when people go to worship, but assume the best when people go to work or go about the rest of their daily lives in permitted social settings. So really we have two diametrically opposite understandings of what is essential, right? How do we draw the line? And I think at some level, it's based on belief that people of faith are going to ignore these guidelines. I think there's a distrust of religion in general. And I don't know, maybe it's deserved, maybe it's not. We had a lot of houses of worship throughout the country in March that became super spreaders, as they were called, and lots of people became sick. We also had non-religious groups where people became quite sick, but I think religion in particular, when you're singing and you're close and you're holding hands and you're praying together, may be more liable to spreading this. The Roberts opinion, though, I think he tried to narrow it at the end. And he said you need to show this indisputably clear claim to relief, and we're at a preliminary stage. This was basically on a request for a stay. And the court usually doesn't grant these sorts of requests for a stay. They're usually very deferential on these emergency issues. So I think John Roberts is basically put the kibosh, if I may, on free exercise cases in Corona. I think we're done. I mean, there are going to be more, I'm sure, but Roberts has basically signaled there's deference. Now, if a case comes up on a cert petition, maybe we'll turn it differently. But these are cases that will all end fairly soon. They might repeat in the fall when we have wave number 2, right? When we get the next wave of this monster. But I think Roberts has pretty much signaled he's not interested in these cases, and he's shown a level of restraint. Cavanaugh shows he's willing to fight for this and go to bat. And frankly, Roberts criticized Cavanaugh. He basically called him, the judicial activist, and charged him with Lochnerism. Ooh, Lochner, right? This evil case with bakers, right? It was pretty brutal because usually Roberts doesn't write separately, and Cavanaugh. Do you know Brett Kavanaugh has been in the majority of 100% of the cases this term? 100. I don't think Kennedy had that high of a batting average. 100%. Now again, we're only halfway through. That will probably drop. But Kavanaugh's gone out of his way to be in the majority of this term. But in this case, he put his neck out. So we have that. 100%. That's not a good thing. I think, I'd be more like Thomas, being maybe half. I think you're on the right track there. All right. That's all I want to say about free exercise religion. Let's talk a bit about freedom of speech and freedom of association. You may have seen in the news, there are a lot of protests. In my hometown of Houston right now, there are a lot of people who are protesting and marching in the streets. Some are wearing masks. Some are not wearing masks. Some are wearing Guy Fawkes masks. Some people are social distancing. Some people aren't. People are spraying liquids that are potentially very dangerous at people. Respiratory conditions are not good with tear gas. There are a lot of things going on right now that, from my layman's perspective, are very bad for Corona. And I sincerely worry and pray that the people at these rallies stay safe and they aren't coming into infection. We've spent so much time trying to keep ourselves isolated, and it seems like in the span of 1 week, we just threw all that to the wind. And people now in public, and I get it. I do get it. I just hope that they're all safe and we don't have what are called clusters that form. But I'll simply raise a hypothetical. Could the state ban all these protests and rallies, saying that we can't have people crammed into narrow, what do you call them, corridors where you're shoulder to shoulder, and there's no way to enforce distancing. We had rallies at the capitals, I think in Michigan, other states, where people always with the ARs in the back, the open carry with the rifles in their back, right? And you try to shut down those rallies, you shut down the legislature. But there's some forms of protesting that only work in person. Tweeting how angry you are only works so much. I think there's something significant when you see thousands of people marching down the street, and there's no other way to replicate that with tweets and Zoom. So I think the state would have a hard time banning them, although I do realize that there are risks to people involved. So I hope they stay safe. Let's talk now about the Second Amendment, the right to keep and bear arms. Almost immediately after the governors issued these stay-at-home orders, some governors deemed firearm stores to be non-essential, and other governors said they were essential. Indeed, in Texas, there was a brief period where it looked like gun stores could be shut down. That did not last very long. Local municipalities in Texas don't have power over gun laws, thank God, right? They don't have that power. It's all preempted. But in states like New Jersey and in Pennsylvania, the governor said that gun stores are not essential. Now, the only way to buy a gun in these states is through a licensed FFL, a federal firearm license dealer. If you can't physically go to a firearm store, you're out of luck, right? You can't buy a gun. And at this time, when people were worried, they wanted to buy a gun for self-defense, they were unable to do so. My favorite example is in Pennsylvania. Gun stores were deemed non-essential, but the Peeps factory, the little marshmallow Easter candies, little Peeps, the Peeps were deemed essential to ensure we had enough Easter marshmallows for the holiday. Give me a break, right? If sugar confectionaries are essential, then an actual constitutional right is really essential. Pennsylvania actually litigated this. They lost at the state Supreme Court by, I think, a 4-3 vote. There was probably going to be an appeal to the Supreme Court of the United States, and what they do, of course, they changed the rule, right? They're playing keep boy. They do not want to lose. They don't actually care about the policy enough to defend it. They just want to keep it in place so the Roberts courts can stop it. In hindsight, Roberts would probably voted in favor of the shutdown, but we didn't know that then. So at least Pennsylvania allowed gun stores. New Jersey is still fighting on this, and there's litigation going on. Related issue involves firing ranges. A gun range is an indoor facility. The ventilation's not the best. If you've ever been to a gun range, it's often very musty, and it's, you have outdoor ranges, which are a lot easier. Those are probably better for this circumstance. But I think the argument goes, if you want to have a gun, you should be able to use it safely. And the way you train is at a range. So some states did have laws banning the firing ranges. I think those are more defensible for the indoor ranges, but I think as long as you have outdoor ranges, which most places have, especially in the summer, it's not that bad. Okay. All right, that's Second Amendment. Number 4, let's talk about abortion for a minute. The blue states, after Corona, they try to make guns hard to get. And what do the red states do? They try to make abortions harder to get. I mean, it's almost like a mirror image of each other. Whatever the red states do, the blue states do. And they did it a little bit differently. They didn't say that doctor's offices were non-essential. Instead, they said that all elective surgeries were postponed. So something like, getting a tooth extracted, or maybe a colonoscopy, right? Or maybe like a nose job, I don't know, right? There are a lot of elective procedures that people had to put on hold. And the argument was, we don't have enough PPE, that is protective equipment, personal protective equipment. We remember the N95 mask was like the holy grail that we none of us had one. We need more masks, we need more gloves, we need more gowns, and all the other procedures. And the attorneys general of some states said that abortions require or abortions may require those pieces of PPE, and we want to save enough for the state. As a result, not all, but a significant number of abortions were put on hold. This was litigated up and down to the Fifth Circuit. The Supreme Court never actually got to it. I think that was probably for the best. They just kind of waited to see what happened in the Fifth Circuit. But the Fifth Circuit basically ruled that the state can ban some form of abortions as a means to preserve PPE, but other forms of abortion that do not require PPE perhaps can go forward. The court also made, I think, an important ruling. In Texas, you can basically get an abortion up until, I think, 22 weeks. I'm checking the number. I think it's 22 weeks. Let's say someone was at week 17, and the person says, I want to have an abortion right now. Fifth Circuit said, no, you can't do that. If you get to week 22, at which point you're going to push past the line, then you can get it. And I think that ruling was significant, that there's no right to an abortion at the moment you want. Shorter waiting periods have been upheld. Casey, I think, upheld a 24-hour one. I think Texas might have one that's a little bit longer. But I think now the law of the circuit in the Fifth Circuit is that you can actually have up to a couple weeks abortion. As long as you have the chance to have one at some point, you don't have the right to have one now. And that's in tension with some rulings from the DC Circuit in a case called Garza, which is about the unaccompanied minor seeking an abortion. And the court said you have to have it right away, that any delay, even of a moment, is a violation of Roe and Casey. So I think you now have some significant Fifth Circuit abortion case law that was made in the background of this virus epidemic that's now the law of the circuit, and was not appealed upstairs. So that's something that could make a big deal later. But the abortion cases also raise general due process issues about the right of a person to resist vaccination, for example. Well, we can't do that, Jacobson. But those cases flew under the radar a bit, but I think will prove significant later. All right, number 5, voting. Oh yes, voting. We all want to talk about voting. I see some politically elected people on this list of attendees. I'm a humble law professor, but voting's important. Perhaps the most significant election we saw was in Wisconsin. We had a race for a state Supreme Court seat that, in most states, no disrespect to anyone, is not very significant. But in Wisconsin became very significant. This became a national affair. President Trump tweeted behind his preferred candidate, and then it just became a huge issue. But of course, we have Corona. People were waiting in line for hours, socially distanced, and it was a sight to see. But a federal judge in Wisconsin actually issued a ruling about absentee ballots that extended the time people had to mail in the ballots past the due date that usually would happen. The Seventh Circuit affirmed this, and then the Wisconsin Republican Party went to the Supreme Court, and they sued. And in basically a 5-4 decision, which I think Cavanaugh wrote because he was a circuit justice, my guess, a 5-4 decision, the court said, nope, you do not get extra time. The balancing test doesn't work here. People can mail it in as long as it's postmarked by the day of the election. People are fine. This was excoriated. Ginsburg said people are going to die, et cetera, et cetera. I haven't seen the numbers how many people died from it. In some regards, the voting rate actually may have gone up than people expected. My general approach to life is things are never as bad as people think they're going to be. Maybe I'm an optimist. I don't know. Things are never as bad as the creative horribles think they're going to be. Things usually turn out better. So keep your expectations low and hope you're pleased. But this was a huge issue. We have another election decision from the Texas Supreme Court. A bunch of cities in Texas, which were run by Democrats, sued, or they didn't sue, but they took the position that anyone who's afraid of COVID has a disability and can therefore request an absentee ballot. That is 100% of the Texas electorate, because we're all afraid of COVID, right? 100% of the Texas electorate can seek an absentee ballot. The Supreme Court of Texas reversed, saying, no, that's not a good reading of the statute. The mail-in ballots are an exception to the rule, not the rule itself. Therefore, you can't go there. Now, that's only state law. Several federal district courts, they forum shop. Several district courts are probably going to rule the federal constitution requires those ballots. Good luck in the Fifth Circuit with that. And I don't think the Supreme Court will intervene. But, it can happen. Right? Things happen. But I think at a minimum, the decision about giving absentee ballots is a decision for the legislature. Now, of course, absentee ballots is a political football, right? No legislature wants to expand them in any state that might be a swing state. So I think you're in this weird space where the courts want to do what they think is right, but I don't think the law gives them that authority. Welcome to the world of being a law professor, right? It's good policy, but illegal. Okay. Let me move on to the sixth point, and then we'll queue up for questions in a minute, involving federalism more broadly. I think from my vantage point, the states have their sphere of authority and the feds have theirs. And we shouldn't confuse those two areas, right? We shouldn't pretend that the federal government is the responsible party for everything. Historically, health and safety laws were responsible for the states. So when this outbreak first happened and the states took the lead, I'm like, yeah, that's right. That's what should happen. And some people said, well, where's the federal government? That's not the Fed's responsibility. They can coordinate, perhaps. They can provide guidance and support, but they can't issue mandates to the states to do things. The fact that the states had insufficient equipment, I think, is a problem. The federal government, I don't think, was particularly competent either. I think they screwed up, but ultimately the responsibility lies with the states. And you actually have states competing with each other to try to coordinate resources. Some states actually form compacts, agreements, which very likely might violate the compact clause. Oh, the compact clause, what's that? States can't form compacts without the consent of Congress. So there might be litigation there, though I doubt it. Breaking news, the Insurrection Act is back in the news. Wasn't planning to talk about it, but why the hell not? One area where the president doesn't need the state's consent is the Insurrection Act, precisely because it's designed to put down state insurrections. These are old laws where the state governments are failing to protect their people. The president can basically send in the military. It's a not good law to use. I'm not a fan of it, but this is one of these rare areas where Congress has given this authority to the federal government. And I guess someone told President Trump about it, and that's why he's buzzing Blackhawks over Chinatown in D.C. This is the world we're in. That's that's all I have for my opening remarks. I wanted to keep it short because Zoom attention spans are quite short. I welcome any questions or comments from the panelists, and you can do this by clicking the raise hand button or by typing a question into the Q&A box. Either way, I'll get it. Thank you all so much. And you can see my hair is getting bigger and bigger. I've got a haircut in 3 months, but that's my world. Thank you all so much. Okay, questions? And if you click raise your hand, I can call on you to speak.
Professor, I'll ask a question.
Sure.
I can take myself off mute and ask it myself. Some of the states had discussed, although didn't really implement, with the possible exception of Rhode Island, the idea of blocking residents of other states from attending. What are your thoughts on that?
Yeah, this is nuts. If I told any of you that we would get to a point where states were erecting roadblocks, where the governor of one state said, do not let in license plates from people of another state, you have said I'm nuts. You said, Josh, you're insane. There's no way that'll ever happen in America. It happened in 5 seconds without any thought. The governor of Rhode Island, Raimondo, I think her name is, issued an order saying any New York license plates can't come in. So there are precedents by what's called the right to travel, right? That people have the right to travel from state A to state B. Okay. Restrictions of that are reviewed very stringently. But what if there's an epidemic and the only way to stop it is to prevent people from coming to your state? I think in the heat of the moment, that was probably a valid measure. I don't think it works now. And let me make this point more broadly. As we learn more about the disease, we learn what measures are and are not appropriate. So violations of liberties that may have worked in March and April don't work in May and June and do not work in July, right? As we get more acclimated to this disease, this virus, we start recognizing what justifications exist that warrant infringement of liberty. And I think Robert hinted at this in his church dissent, the Pentecostal case dissent. A lot of the measures I think were fine in March. I think some were completely arbitrary, especially involving an enumerated right in the Constitution, but they probably would have passed muster. But thank you for the question, Chad. Who else? Any questions on the line? Well, Chad, maybe I can ask you a question since no one's raising their hand, a bunch of very shy Federalists. What's it like on the ground in Little Rock now? How are things going there?
So in Little Rock, we've had a number of protests each evening. Nothing that would compare to what we've seen in other cities, but last night we did have a number of windows broken downtown. We've had several protests that were broken up by tear gas the last 2 or 3 nights. We now have an 8 p.m. curfew that's imposed tonight. I'm not sure how many nights after this. It's not as severe as it's been in other states, but I'm not a big fan of the trend. We've also had a few other cities in Arkansas that have had protests that were disrupted with tear gas. It's
Have all of your stay-at-home orders been lifted?
We were actually never under an official stay-at-home order.
Really? City or state?
We've phased in back the few restrictions that we did have slowly been lifted, but we never did issue a formal stay-at-home order in Arkansas.
Okay. Well, we are more or less open, although I'm still firmly stuck at home. Okay. Any questions from the people on the line? I see about any hands up.
You can type them in the Q&A, or you can type the raise hand button.
I think people are shy, or they're not listening, or answered all their questions. I'm just that good.
I'm sure it's the last.
We have a hand. Thank you.
Bless there's a hand. Evelyn.
Okay. Evelyn, would you like to speak?
Take yourself off mute.
Sure, I'm off mute.
Yep.
So, as an election commissioner, we're looking at a lot of issues, and redistricting is coming up, and there's a lot of issues coming up in the near future. You touched a little bit about elections. I know there's some movements for vote by phone and all kinds of insanity going around. Is there anything else that you'd like to expound upon with those some of your notes about elections?
Sure. Yeah. Well, the Supreme Court has established some balancing tests for the right to vote. Right? The idea is that the right to vote is burdened when you have these various factors, which are not very important to get into. These are very mushy tests. With Corona, it's not like traditional thing where you're trying to gerrymander against certain political parties or gerrymander against certain racial parties. These are health concerns that ostensibly would apply broadly to wide swaths of people. Now, for sure, Corona impacts some people more than others. We can go through the comorbidity tables for sure. But I think the danger is not for laws you guys enact next year under the normal course of order. I think the risk is on the eve of the 2020 election, plaintiffs bring federal court judges these cases demanding emergency relief on very short time with almost no recourse, at which point you need basically either temporary restraining order or a preliminary injunction. And at that juncture, it goes right to the Supreme Court after a few days. So I think the 5-4 decision in the Wisconsin case shows us that the name of the game is going to be deference. Maybe that's John Roberts' redeeming quality. He defers to the government, and when it's conservative government, the conservative wins, and when it's liberal government, the liberal wins. So I think Roberts is probably game to rule against all these voting rights claims. I think Kavanaugh is probably in the same boat. I don't like saying it like that, but that's probably where we're headed. A lot of 5-4 decisions at the court.
Oh, fun.
Thank you, Evelyn.
I had a question from Judge Radofsky that he texted me and asked me to read.
Your Honor, how are you, sir?
On the phone. His question is, how much deference do you think Congress or a state should get in its medical judgments regarding what is necessary to combat corona? How much should a court say, no, that's not right on the medical front, versus, well, there's a lot of unknowns on the medical front, so we're going to defer a lot to the legislative or even the executive branch?
Right. Thank you, Judge. Your question, Judge, is basically the distinction between Roberts and Kavanaugh. Roberts thinks that the state can draw a line between a liquor store and a nail salon, which is open, and a church, which is not. Because the state says, well, people are congregating in churches, but they're not congregating in liquor stores. Maybe that's a rational judgment. Maybe it's not. I would just tweak it slightly and say that we're not dealing with some unenumerated right here. We're dealing with an enumerated right. And the sort of deferential standard from Jacobson versus Massachusetts belongs to substantive due process, belongs to unenumerated rights. So I think in the abortion cases, Jacobson was the correct rule. In fact, Roe v. Wade cited Jacobson. It cited it. I've always taught that part in class. But we're dealing with the First Amendment and the Second Amendment. We're dealing with, it's almost an actual constitutional rights, but enumerated constitutional rights that aren't subject to the sort of vague and nebulous analysis. So in those cases, I think you need to have a little bit more rigor in your review, a little bit more oomph, if you will, and just accepting the government's pleadings at face value doesn't fly.
There's a Q&A.
Yeah, I see the question. The question is, has the coronavirus crisis impacted freedom of speech? The person says, I don't want to speak on camera, though. Thank you for your presentation. You are very welcome for the question. I think the speech case happens when, let's say, people tweet out false information that's potentially dangerous. Like someone says, I have a cure for corona and I want to sell it. Well, that's sort of fraud. Maybe put that in one bucket. But someone else says that, so-and-so has corona. And someone else says, well, there's a corona outbreak on that block, right? Or someone says, go here for testing, and there's not. Giving false information that can harm people can, in some contexts, actually be criminal. One of the most famous examples I can think of is during a hurricane, people say that, this building is underwater, or right, this building has no electricity, and people change their action based upon it. So I think there might be some spaces for the government to actually punish false information during crises. But again, we're now in month 3 of this nonsense, right? A lot of the urgency, I think, is faded, right? People are now marching shoulder to shoulder with that mask on, and no one seems to care anymore. A lot of the, exam hypothetical questions were from March. I think, thankfully, we're over that hump. But thank you for the question.
Professor, I had another question that was sent in to me from our Lieutenant Governor, who, just for your background, is also an active duty JAG officer for the National Guard. He wanted to know, he wanted you to talk a little bit about Posse Comitatus.
Oh, God.
And
oh, God.
If you had any thoughts on using the military for domestic purposes during the current crises.
Look, I'm not an expert in Posse Comitatus, Governor. You probably know more than I do about it. What I'll say is I'm just very generally skeptical when the federal government uses military force not on domestic soil. We saw some of this after Hurricane Katrina in New Orleans. After Katrina, you basically had federal military officials going door to door in these neighborhoods, among other things, seizing weapons, seizing guns. I am not a fan of that. I think if we can use but state officials to put down these sorts of protests, we should. I suppose one difference is when you have a natural disaster, people are sort of in a very rough state, whereas when you have riots, you need potentially something stronger, but I think it should be discouraged as long as possible. I don't want thousands of very big, strong soldiers with many, many arms walking around. I say this, I'm in the city of Houston, where there'll be a funeral in a couple of days of some note. I don't think Posse Comitatus should have any place in this discourse, but maybe the JAG has a different position. But thank you, Governor, for the question. Lieutenant Governor, I'm sorry, I just gave you a promotion. If your boss is thrilled. Lieutenant Governor, I'm sorry. Other questions, either in the chat or by raising your hand. Going once. Going twice. Anything else from the queue, Chad? From the text?
That's everything I had.
That's all I have.
Thank you again for
Thank
great
you.
presentation.
Very grateful. Thank you.
Thank you very much. Thank you, everybody, for attending today, and we'll try to do another one of these in the future. If anybody has thoughts on time or any other speakers you want to bring in, please let us know.
And if you didn't buy my book, it's on Amazon for $23. 100 Supreme Court cases everyone should know. Thank you so much.
Excellent. Thank you very much, Professor.
Bye-bye.
Have a good evening.